What are some common professions of individuals that are applying for EB1A?
Common professions. Okay, so like I mentioned, this EB1A is for anybody who has extraordinary ability in arts, science, education, business, and athletics.
Hello, everybody. In today's video, I'm very pleased because we're joined by attorney Hannu Huikuri, and we're going to be talking all about the EB1A visa option. This is an immigration option for people that have an extraordinary ability in a particular field. And one of the reasons why it's so interesting and it's such an exciting option for people is that through the EB1A visa, somebody can obtain a green card for themselves and their family members without having an employer sponsor them through a job offer. The EB1A is a green card option that's eligible for self-petition. So as you can imagine, it's a immigration vehicle that people have a lot of interest in. And again, in today's video, we're going to be talking all about it. So welcome, Hannu. It's a pleasure to have you join us today. And thank you for being here.
Thank you so much, Michael, for inviting me to discuss the EB1A.
So to get us started, could you please provide us with a high-level overview of EB1A? Tell us a little bit about what it's all about.
Yes, of course. I mean, you already touched upon it a little bit. It's for individuals who have demonstrated extraordinary ability. It's leading to permanent residency, so it's an immigrant visa as opposed to a non-immigrant visa. And if the O1A is the non-immigrant visa, I call it the big brother or big sister or a little brother or little sister of the EB1A category. So the EB1A is leading to permanent residency, and you have to demonstrate extraordinary ability in fields of science, arts, education, business, or athletics. And people sometimes refer to this as the Einstein visa, but it's technically not that difficult, or you do not have to be an Einstein to obtain the EB1A, but it's definitely a little bit more restricted than some other employment-based immigration categories in terms of the eligibility criteria. So it does require the individual to show that they have risen to the top of their field, but there are, of course, ways how to prove that in terms of documentation. But yes, it's a good avenue for permanent residency. In some cases, very fast also due to some employment-based immigration petitions or categories having the backlog of too many applicants in terms of like the annual quota. So a very good avenue in terms of that.
Thank you for providing that answer. And you touched upon the fact that eligibility, as you said, it requires a higher standard than some other immigrant visa options. And we'll discuss those requirements shortly. But I wanted to ask you specifically because a lot of times when people are considering EB1A, they're also considering EB2 national interest waiver, or they might even be considering EB1B for outstanding professors and researchers. So can you touch upon how EB1A differs from the national interest waiver or from EB1B or those other categories?
So EB1A is similar to EB2NIW in a way that it doesn't require employer sponsorship, like you mentioned in the beginning, which is basically a very good benefit of the category. So I can discuss later about the PERM process, which is the reason why the self-petitioning is such a viable path for so many. But you do not need employer sponsorship for the EB1A or for the EB2NIW. You will need that for the EB1B when you are applying for the outstanding professor or researcher category. So that's the difference between those two. And the EB2NIW, what sets it apart from the EB1A is that it will look at some other factors, not just your own merits or achievements, but it also will look at impact on the US or whether your work or field is within the US national interest. And this is not a consideration in the EB1A extraordinary ability category. So it mainly focuses on yourself and your achievements. Of course, you have to touch upon the fact that you will be continuing in the same field of expertise that you claim to have the extraordinary ability.
Let's go to the benefits. And we've touched upon the benefits, of course, but what makes EB1A particularly advantageous when you're weighing it against the PERM process or other avenues to get a green card?
Self-petitioning, like I mentioned, the PERM process, which is basically maybe the most common way for an individual to obtain an employment-based permanent residency in the US, which that will require employer sponsorship. And it will also require what's called a labor market test. So the perm process will require your employer to test the labor market for qualified US nationals that are willing and able to take your job. So that is something that creates, first of all, a lot of uncertainty, and it also creates a lot of delay in the process. So the perm process usually takes many years, and you are also very tied up to the same employer who starts your perm process. So as long as you do not have the I-140 approved, you're basically tied to that same employer in a way. But that all is set aside when we're thinking about the EB1A. So you don't need to have your employer in that process present at all. So you don't have to inform them that you're applying for the EB1A. So it gives a lot of free movement in terms of like planning your future in terms of the immigration. So that's very good. And for example, I think we can also discuss this a little bit later, but there are certain countries that there is and remains a backlog for the EB1A category. So nationals of India and China, they still have some wait time in terms of getting a green card via the EB1A, but that's very much shorter than compared to the EB2 and EB3 categories. So we are not looking at decades-long wait times. And then I think that makes it a very appealing and interesting category in terms of applying.
Those were great points made. And to recap some of them, through the perm process, you're looking at, as Hannu mentioned, that labor market test, and along with the other corresponding elements of the perm process can take years to complete. There's the uncertainty associated with the perm process. Again, you're testing the labor market, and if a qualified applicant applies for the position, that could potentially be devastating to the perm process for the potential beneficiary of that process. Again, if you are a national of a country that has a visa retrogression under EB1A, the wait is likely going to be far less than for other employment-based categories. So again, there's a lot of benefits here to the EB1A, which is why it is understandably a popular option and an option that we'll have interest in. And with that, I would like to ask you, Hannu, about the eligibility requirements. We've now covered benefits, we've covered an overview of this category, and now let's get into the requirements.
I can provide a kind of high-level overview of the requirements. So in order to be eligible for the EB1A, you have to pass a two-step test or two-step analysis of your extraordinary abilities. Basically, for the first step, you have two options of how you're going to be satisfying that or passing the first test. You can show one-time major achievements. So basically, we're talking about an Olympic medal, an Oscar win, or a Nobel Prize. And of course, that's not that many people who have received those kind of one-time achievements. The second one is that you can satisfy at least 3 out of 10 of the listed regulatory criteria for the EB1A. So basically, those 10 regulatory criteria, I can give you a few examples of those. So instead of with that one-time major achievement, you can show a receipt of lesser nationally or internationally recognized prize or award. You can show that you're a member of an association in your field of expertise that requires outstanding achievement of their members. You can have press material written about you so you can be featured in newspapers, and there are also specific requirements as to that category as well. You may have been asked to judge the work of others, or you have contributed to the field. So these are kind of the examples of those regulatory criteria, of which you have to satisfy at least 3 in order to move on to the next step. And the second step is basically a final merits determination. And I can discuss about the final merits determination for hours, but let's keep it also very short. So the final merits determination is actually not included in the regulations, but it's rather based on some old case law. And after that case, USCIS have adopted this final merits determination in order to assess your eligibility. So the final merits looks at sustained national and international acclaim. So basically, it's looking at a time frame of achievements. So I'll give you an example. Let's say we file your EB1A in 24, and if your evidence that you provide shows that all of your achievements, all of the at least 3 out of 10 criteria focuses on the year 2024, then you're really not sustaining that extraordinary ability or acclaim. So that is always something that USCIS will look at in their final merits determination.
First is what? So you mentioned that if all those criteria were satisfied or all those criteria were hit in 2024, it's not evidence of sustained national or international acclaim. So what would be the alternative that would be more of a clear indicator of sustained national or international acclaim?
Right. So then we're looking at a little bit more longer time frame that we can show that the sustained acclaim. So I recommend that, it's better to have a little bit of a track record in terms of the extraordinary ability, especially in terms of the evidence. So that's something that USCIS many times has raised in their final merits determination analysis, that claim has not been sustained for a long period of time. It doesn't have to be decades, but it can't be like a couple of months before we file the application or petition.
And similarly, if the acclaim was from
Right.
2005,
Yes,
and since then there
absolutely.
hasn't been much happening and you file in 2024, then it's also a situation that could similarly result in a finding that the acclaim has not been sustained. So a claim that's been obtained too recently, and then also without enough of a track record and history, and similarly a claim from years and years ago that has not been sustained over the years.
Right. So that's definitely something, it's not enough that you satisfied those three criteria and provide evidence from 2012 or 22 to 2005 or something like that, but rather it has to be a coherent time frame before applying. And then in terms of the final merits determination, there's another factor that the USCIS will look at, and this turns into kind of a subjective analysis. So overall, the final merits determination is sort of subjective in terms of that the USCIS officer will have very much discretion into this analysis, which is, of course, when we are attorneys and we are arguing cases, we don't like anything that has room for subjective interpretation. So what the other factor that they're looking at is the totality of evidence showing that you have risen to the very small percentage on the top of your field. And, in terms of like how we overcome that or how we satisfy that, well, we have to provide enough evidence to show that you have satisfied those three criteria. And sometimes it's a tough battle, but we can discuss that a little bit later. And then finally, in terms of the eligibility, we already touched upon this, but this pertains to the intent of continuing to work in the same field or field of your expertise. So you can't be an expert in software engineering and then present to the government that you will be writing a book at the beach. So even Congress, in their draft of the EB1A regulations, they mentioned that one must not remain idle after issuance of the EB1A. Rather, they must pursue the same endeavor as they are doing currently, or what their field of expertise is.
It's not just field that can be as diverse as software engineering and writing a book on the beach, but even if, for example, your area of extraordinary ability is in coaching a particular sport, and then your proposed endeavor in the United States, what you plan to do is in actually playing that sport, that could also be enough of a difference to not be exactly in line with your area of extraordinary ability.
Right. That's correct. So interpretation is kind of strict in that regard as well.
And how you ultimately classify what it is your area of extraordinary ability and how you document evidence of that extraordinary ability is a strategic endeavor for this exact purpose of what you ultimately plan to do in the United States. So we covered it requirements now. What types of evidence do you find that your clients will typically include to demonstrate evidence of extraordinary ability in their field?
Right.
Let's make it very concrete for people to see they're going into this process, what types of evidence they could expect to include in their case.
Okay. So first of all, each case is unique, so we can't really draw any kind of generalization of what sort of documents, but we can take a look at a couple of examples. So maybe we can see an example of something that I see that is creating some confusion along the applicants. So let's look at the membership requirements, so criteria. It's not enough to be a member in an association, but we have to also show the subsequent requirements. And the subsequent requirements are membership in an association that requires outstanding achievements of its member. So I am a member of USA Ice Hockey Association, but that doesn't make me an extraordinary ability ice hockey player. So we are looking at some level of outstanding achievement that is required for entry in membership into the association. So basically, in order to satisfy this requirement, we have to, of course, show documentation about confirming that you are a member and that association is in the field of your work and it requires outstanding achievements. So how we can provide evidence of that is maybe the association rules or bylaws that has the membership requirements. And sometimes it's a little bit difficult to show this because wordings of rules or bylaws that don't mention outstanding achievements, but we have to show there needs to be same or similar kind of verbiage in the rules of the association.
So if you can buy your way into that association without any sort of merit, that's obviously a factor that would cut against
absolutely
meeting that
Yeah,
prong.
absolutely. And, in my cases, I prefer this, I call it organic achievement. So something that you've paid for is never a good thing. And I think USCIS is also aware of these kind of attempts of individuals trying to buy their way into the EB1A. So membership and awards and everything else, it has to come naturally and organically, so to say, in terms of the EB1A.
Well, that was a helpful illustration of some documentation.
Actually, I have another one. So this is about press or published material about the applicant's work. So I've seen this many times from prospective clients and current clients that they provide news articles about themselves, but the articles is not written about the applicant's work. So they may have been featured in Washington Post or New York Times, but it's about how they spent their days at the beach or when it's hot. But that's not about the work of the applicant. So it has to be about your work, of your expertise. It has to be published in major media outlets or professional journals. So it's not enough that the article is featured in a school newspaper. So we have to provide evidence of basically circulation data of the outlet where the article has been published. So that's another consideration to keep in mind when providing evidence or considering whether I satisfy these criteria.
What are some common professions of individuals that are applying for EB1A?
Common professions. Okay, so like I mentioned, this EB1A is for anybody who has extraordinary ability in arts, science, education, business, and athletics. So thinking about a specific profession in terms of that may not be the correct question, but I think for individuals who work in technology or research, they have the advantage of maybe having an easier way of showing or proving some of the regulatory criteria. As let's say a researcher they have published a lot of research which have been widely cited by other experts. That can be very easily shown via, for example, Google Scholar site or ResearchGate. And then if you're in technology, maybe you have patents or something like that. So those are very easy to show original contributions also. So maybe those individuals tend to apply for the EB1A more often because it's a little bit easier for them to show their eligibility or satisfying the criteria.
It adds an element of objectivity to this process that it can be at times uncomfortably subjective by pulling up a numeric figure like the number of times your work has been cited to, for example. In line with that question, I want to pose the alternative. And what are some unconventional industries that you have seen people have success with in EB1A?
Well, from my perspective, and there's actually case law about this, but foreign trained attorneys. So if you are a foreign trained attorney who is an individual, attorney with extraordinary ability, there was a case about an attorney not falling in any of the fields required for the EB1A. So technically, an attorney is not in sciences or they're not in business or education. They're practicing law. So how do you show that they fall into any of these expertise field? Well, I would argue that foreign trained attorneys, especially if you're a partner or in higher up or you own your own firm outside the US, there is a lot of other things than practicing law that comes into play when you're running your firm or being a partner or a senior attorney. So there has been, and you can argue that your field falls under business because there's going to be a lot of business development, for example, sales and marketing efforts, etc. Maybe if you are a transactional attorney, there's also a lot of work that goes into advising companies of mergers and acquisitions. So those kind of elements will speak favorably into that. Being an attorney, you can also be eligible under the business field.
And then you would document extraordinary ability in business?
Yes. So basically you would have to create a coherent narrative, of course. You can't just jump into business in terms of the field. So you have to have worked in the areas that we are going to be presenting as falling under business. So let's say business development, mergers and acquisitions, etc.
And through that strategy, it widens the umbrella for many industries. Like a
Right.
barber could theoretically assuming they satisfy the requirements, qualify under EB1A under the right set of circumstances. So, okay, now I want to go into your analysis when you're engaging with a prospective client for EB1A. What are you looking for in your assessment of that individual's background to determine whether you should proceed with that case, whether they should proceed with that case? Take us into your mind when you're evaluating one of these cases.
Right. So first of all, of course, I make sure that we satisfy more than just the 3 out of 10 regulatory criteria. So I will look at the background of the individual to see whether those criteria have been met. And then I look at the track record in terms of the history. So like we already mentioned, the sustained claim part. So I will focus on whether the extraordinary ability has been sustained for a longer period of time before we apply, and it hasn't been too far away in the past. So that's kind of the 2-step analysis that I'll do to make sure that the case is viable and we have a chance to get it approved. So I focus on the track record a lot, and then, of course, the regulatory criteria that we have everything covered there.
And that brings me to my next question. How important are letters of recommendation to an EB1A petition? And to what extent are you finding out who this individual has to recommend them before in your evaluation process of the strength of this individual's potential application? So 2-part question, I guess. And starting off with how important in general are letters of recommendation to the petition? Take it from there.
Yeah. So basically, they are very important, but I like to call them semi-objective evidence. So they're not subjective evidence as to say that they can prove a fact to be true, more likely true than not. But in themselves, they cannot prove a fact to be true. So they are an amazing way of proving an element true. So you have to have supporting evidence also in terms of, let's say that you are arguing the scientific contributions or scientific publication. Of course, if you have a recommender who knows your history in terms of your research, in terms of your publications, and they can speak about that, that's wonderful. That brings, more strength into the argument that you satisfy that requirement. But you should never try to evidence one criteria only via the recommendation letters. And the recommendation letters, they are a little bit different than your everyday other run-of-the-mill recommendation letters. Let's say like for university admittance or employer recommendation. They are very specific that they need to speak about your work and speak about the kind of impact that you've had on the field, or like in the EB1A field, the kind of similar content of those. So yes, they are very important. And of course, in my kind of routines, I of course always discuss with the potential client and of course the client to see can they provide, or do they already know who can be their recommender and what sort of facts can they provide about the applicant in general, and also about their achievements.
Do you have a minimum number of letters of recommendation that you look for when filing a petition?
Right. Yeah. I mean, I'd say the sweet spot is 6 letters. So we don't want to have too many. I think we can cover enough evidence and enough facts with 6 letters. So that's kind of the sweet spot. I've had success with less, but I've had success with more letters as well. But that's kind of the sweet spot there. 6 letters.
Moving on. So EB1A, what is the processing time in general from start to finish? What does it look like in terms of what applications get filed? And then also part 2 is premium processing available for EB1A? And if so, what does that processing time move to if an individual avails the optional premium processing service?
Right. So in my experience, the process of the first initial call with the attorney up until filing the petition, it's usually around 3 to 4 months. That depends a lot about like how ready you are in terms of have you gathered any of the documents, for example, how easy it is for you to start collecting the documents. So, document collection takes a lot of time, especially the recommendation letters. You have to chase the recommenders sometimes. So you have to factor that in. But, you are very organized and you have everything ready. It should not take, that long in terms of like when you're working with an attorney to file the application. And one thing to keep in mind, or one important factor here and one important advice is you should never hurry with the EB1A preparation process, because you want to have the application or petition as good as possible. And what does 2 weeks of earlier filing matter if, there's so much at stake? So you have to kind of make that balancing. So I usually recommend that we, spend enough time in preparing the case. So that's one thing. And then the premium processing is a very good option. Like that, this is one of the benefits of the EB1A. So when you're filing with premium processing of course, there's extra cost for the government. So you have to pay a government filing fee of $2,805 for that. But it will get you that decision in 15 business days, which actually changed quite recently from 15 days to business days. So, but that's a very good benefit. And one thing to keep in mind is also very important that premium processing will not get you in front of the visa backlog or the visa backlog line or the retrogression line. So let's say that you are an Indian or Chinese national, you'll still have to wait for a few years so that you're able to apply for the green card and the green card or a visa becomes available. So basically, premium processing is only for the I-140 that is filed along with your EB1A. It can't get you in front of the line, so to say. And I see a lot of in the EB2 and IW fields because sometimes people think that paying the premium processing will get your green card in 45 days. Well, that's not the case. I-140 will be approved or something else happens in that 45 or 15 business days time frame.
So if somebody is subject to the visa backlog and their priority date is not current, do you typically, and it's probably for you a client-to-client analysis as opposed to like a blanket policy, but do you ever see value in avoiding premium processing? Do you ever see downside in filing a case with premium processing? And of course, not official policy by USCIS, but do you ever notice that a case filed with premium processing may be more likely to get a request for additional evidence?
Right. That's a very valid point. And unfortunately, we don't have exact data on that. I would like to see. We only have anecdotal information. So we might have anecdotal information that when you're filing premium processing, and you have to factor in that the one individual officer has multiple applications on their plate, and that premium processing is, of course, making it so that they have to kind of rush your case in a way. So that might lead to the conclusion that the adjudication quality in premium processing may be lower than in the regular processing. But although I have to say that I've seen some bad decisions also in the regular processing, so that kind of takes away the basis of that analysis that premium processing may lead to worse results. So I wouldn't worry about that, but because we don't have that data, and in my heart I'm a scientist, so that doesn't really resonate with me if we have only rumors or anecdotal information. So I'd stick with premium processing if that is in your best strategy.
So we got to the I-140 stage, but let's carry it all the way through to the conclusion. So the I-140 is the immigrant petition. This is the petition where you're including all your evidence that we discussed, evidence of your extraordinary ability, your awards, your letters of recommendation, etc. The time that it takes to prepare and file that is very much in the hands of the client, because it's on their end how long it takes to accumulate and provide that level of documentation. So that can vary. But as you mentioned, in your experience, the average comes out to somewhere between around 3 to 4 months, you would say, if I recall.
Yeah.
But that's
Yes.
essentially one part of a larger ultimate plan to obtain the green card. So can you talk about the other steps involved?
Yeah, you can do it two ways. So basically, with the I-140, along with that, you can concurrently or the same time, you can file your I-485, so your green card application. So you have that option, or you can first file the I-140 and then wait for a decision on that and then file for the green card. But we're still looking at processing times in terms of the green card being quite long. So it's never a quick solution when we're applying for immigrant visa. The processing times can also, of course, they vary a lot. So you're looking at somewhat of a significant wait time after you file the green card. For Indian and Chinese nationals, you have to look at the visa bulletin, which is a kind of document that is published by the government on a monthly basis, which I like to simplify it. It shows your place in line. So when we file the I-140, you'll get what's called, and that priority date will be your place in the line. First in line, so to say. You can then file your green card, and it takes its time to process again. And then once a visa number becomes available, or a green card basically, then the USCIS can issue your green card. So the approval of the EB1 I-140 is not the end of the story. You'll still have to wait for the green card to be issued, which can take a significant amount of time, especially when you are Indian national or Chinese national.
I-140 is one step of basically a two-step process. If you're lawfully present in the United States in some valid non-immigrant status, then you can adjust your status by filing a Form I-485, as Hannu mentioned. If a visa number is currently available for you, if your priority date is current, you can simultaneously, concurrently file your I-140 along with your 485 adjustment of status. If you are outside of the United States, then likely the process for you would be to first file your I-140. Upon approval of that I-140 and assuming that a visa number is available for you, then you would do consular processing to obtain your immigrant visa outside of the United States. Upon your admission to the United States with your immigrant visa, you would be a lawful permanent resident at that point. With that, I want to go into areas of challenge. Where does USCIS typically push back? I'm actually going to combine a couple of questions that I have here together. What are some areas of pushback from USCIS? What does USCIS typically take issue with in an EB1A petition? And taking it a step further from that, what are some reasons why USCIS will deny an EB1A petition?
I would say that the biggest challenge is this step to totality of evidence analysis or final merits analysis. So like I mentioned, there's two tests that you have to pass. So first is the regulatory criteria. Of course, we sometimes see pushback on, if we are not careful or we haven't provided enough evidence to satisfy those. But the most difficult part or challenge is the kind of final merits determination. Pushback from USCIS where, like I mentioned, it's kind of a subjective analysis that USCIS is making based on that one old case, Kazarian versus USCIS, after which they adopted this framework of evaluating EB1A petitions, this kind of extra framework for this analysis. And that creates a lot of gray hair, the second one, the step 2 analysis, if there's pushback on that, because, well, it's subjective in a way, and then we see a lot of confusion along with like USCIS officers in how they kind of approach this, because if you look at some of the denials and maybe some of the old cases, you can see that they somehow mix up the criteria with the totality of the evidence analysis, which is not how it works. So totality of the evidence is separate from step 1 analysis. So this is something that we will see a lot of pushback on this final merits step 2 analysis. And I think I can take this a little bit further in terms of like answering, because what we can do about this, of course, is we need to think about strategies after, for let's say hypothetically we get a denial on the EB1A on basis of final merits. What are the options? I mean, that's like kind of the logical next question here. What are the options that we have after that? Basically, we can then refile the application or the petition and make adjustments to the filing based on the feedback we receive from USCIS. We can also withdraw the petition before the USCIS issues a final denial. So let's say we receive a notice of intent to deny, and then we strategize whether it's better to withdraw and refile, because this is the subjectivity of the whole petition. So there's strategy there in play as well. And a denial is not the end of the world. It doesn't mean that you can never apply for the EB1A. It doesn't preclude you from filing the EB1A again, nor is it in any way, especially from my experience, it's not in any way, you're not prejudiced by the denial. So meaning you can still apply for the EB1A without it having that much of an effect on your chances of approval. And now immigration attorneys are ecstatic about this option, because quite recently there was a Supreme Court case called Loper versus Pride, where an old doctrine called the Chevron doctrine was removed. So the Chevron doctrine made it very difficult to challenge administrative agency decisions. So now the Chevron doctrine is not in existence anymore. We have the option of litigating anything that is based on the final merits determination. Because like I mentioned previously, the final marriage determination is not in the law or the regulations. It's basically an old case law or based on a case that was then later implemented by USCIS. So we have ways of challenging that in court. Of course, that brings its own host of drawbacks, such as, you have to wait a little bit, and then it's can get a little bit expensive to litigate these cases in federal court. But I think that's a hopeful turn of events, in my opinion.
So just because you brought that up, with the new administration coming in, there's a lot of fear surrounding immigration in general. My question to you is, what are your thoughts about how the new administration could result in any sort of differences in adjudication of EB1A petitions? And I ask this because while there is a lot of fear, there has also been a lot of pro-immigration sentiment as it pertains to merit-based immigration. And certainly, if any category of immigration qualifies as merit-based immigration, EB1A is, I think, among the most well-fitting category for such a category of immigration. So with that, what are your thoughts on how the incoming new administration could have an impact on EB1A adjudications?
We can actually do a kind of analysis of how they handled or what was their stance on the EB2 and IW, because I think based on the statistics and during the previous tenure of the upcoming administration, the approval rates actually increased in the EB2 and IW category. So we can kind of draw a conclusion from that they think that this, well, at least EB2 and IW is also a little bit like merit-based. Of course, it looks into the impact of the US in a broader scale, but I would assume that similar trends may happen, especially in terms of like what we've heard in media in the last couple of months from the representatives of this new administration. So I would even go that far as to speculate that it might be a favorable thing in terms of adjudication trend for the EB1A.
Hopefully many people find that to bring them some comfort. Some good news, I'm sure, is very welcome among our audience. I'd like to gear this next question towards entrepreneurs. Can entrepreneurs utilize the EB1A visa? And if so, what are some of the categories that they will typically satisfy to evidence their extraordinary ability?
Like I mentioned previously, each case is very unique, and we have to do a unique analysis based on the circumstances of that individual. But the answer is, of course, yes. If you satisfy at least 3 out of the 10, and then the final merits, then of course you are eligible, even though you're an entrepreneur. But we have to strategize a little bit in terms of what sort of documents, and maybe entrepreneurs may face some extra challenges in terms of what can they show, and we can be creative there as well. So let's say, for example, if you are in the US or you have a US startup, but you have a track record of being a successful entrepreneur. If you have secured funding, we can definitely show evidence, some of the criteria. We can show, for example, membership in an entrepreneur accelerator program, for example, to show division membership criteria. And then I'd also keep in mind that it would be beneficial if there is a proven track record in terms of financial success for an entrepreneur. So when you're an entrepreneur, if that's purely business, then of course that focuses on the numbers. But of course, if your company focuses on products, for example, then we can show patents if you have any of that. But definitely the same principles and rules apply for entrepreneurs as well. And they are, of course, eligible if they satisfy the criteria.
Absolutely. And when it comes to remuneration, of course, evidence of high remuneration is one of the criteria, and that can be both salary and I've seen successful arguments made when factoring in share value of the stock that they own in a particular company. So
Right.
That is also something to consider. Yes. So I want to get to one of the oftentimes most interesting parts of a video like this, which is to go over some case studies. If you have any case studies that are interesting of EB1A clients of yours, the floor is yours to share those.
Yeah, I'm going to stick with the foreign trained attorneys because that's so close to my heart. So bear with me on that. So basically what I had challenged in this case was, of course, to how to tie the lawyers or the attorneys past into the business category. My clients, without going into, specific details, but they had a very good track record of research They had a very good track record of scientific publications. They had a track record of press. They have been in a very critical position in a distinguished organization, but none of that was anyway related to business directly. So we had to kind of go outside the box a little bit and focus on the factors that actually tied her history into business. But luckily, in the past few years before applying, she had made several, I would say, career moves that placed her into the field of business more. She was advising startup companies also in terms of legislation or legal advice for startup companies. So that's something that kind of pushed her over the business into the business field. But that was definitely an interesting case because you had two levels of obstacles, so to say, that you had to overcome. First one was that the business side it was from the past couple of years before filing, and then the previous accomplishments were not directly in business, but more like indirectly in the field of business. But we got it approved, which was without any issues, which was then amazing, of course, for her future.
Congratulations to you and your client on that. Very interesting indeed. Hannu, are there any specific countries or regions where applicants might face unique challenges or advantages when applying for EB1A?
Yeah, I think we mentioned previously about the visa retrogression for individuals from certain countries, and those are Indian and Chinese nationals. So compared to some other countries, they are facing a little bit of a wait time. But I would not say that, if you compare that wait time to EB2 or EB3 visa retrogression and the wait time, that's considerably faster still. We're still talking about only a few years in terms of being able to file the green card and getting the green card after the I-140 has been approved. So that's definitely a challenge. You still have to wait after getting that I-140 approved. But what I've also seen is that many of my Indian clients, they've had an approved I-140 for example, from a perm process. Let's say that their employer has already started their perm process and that has concluded and the I-140 has been approved. You can use that priority date from that previous I-140 in the circumstances, and then you can basically file the EB1A green card. So it means that you are current in terms of the visa backlog. So you can then file the green card at least at that point, and maybe the visa number is already available for you. So definitely that's something that usually I see from my Indian clients. But Indian and Chinese nationals, if I see them in H-1B, there's further benefits from filing the EB1 or getting an approved I-140 from the EB1A. So if you are in H-1B and if you have a spouse, the requirement for the spouse to receive employment authorization is that the primary applicant has an approved immigrant visa petition, so an I-140. So basically, even though the backlog is still existing, getting approval from an I-140
make your spouse eligible to apply for work authorization.
And this is sometimes, we talked about changing the administrations, and this has been in this topic of a lot of discussion. So we are kind of uncertain what will happen with the H4 EADs. But as for now, that situation remains so that with an approved I-140, your spouse can obtain work authorization. And then if your situation is so that you've exhausted your maximum of 6 years in H-1B, maximum period of 6 years, if you have an approved I-140, you can extend for 3 years or until a visa becomes available. So there's some possibility of extending beyond that 6-year maximum if you have an approved I-140. So definitely there are benefits there. And those benefits apply also to EB1A. So even though the wait time for Indian nationals is a lot longer there, you will still enjoy those benefits in terms of your spouse getting an EAD and then your ability to extend your H-1B post 6-year maximum.
So what are your top tips for somebody that's considering EB1A?
I would emphasize patience. So nothing good comes out of haste in terms of the EB1A. So you have to have patience where, we discussed already the sustained acclaim. If your achievements are from the past couple of months, that's definitely not a good sign. That's I would call it a red flag. So if you're able to have that patience of, building kind of your EB1A profile and making sure that you're able to document those achievements very carefully. So That's definitely one of my tips for success. Also, work with a competent attorney. So this EB1A, like I mentioned, it's a kind of restrictive category. It's not for every individual. And we have to overcome a lot of hurdles to be successful. So working with a competent attorney is definitely something I recommend always when applying for EB1A.
What are some misconceptions about EB1A? And we covered some of them earlier in this video, throughout the video, just through our natural course of discussion. But if you want to highlight any of them here.
I sometimes hear that, okay, as in addition to also to the EB2 and a W category, I hear a lot about this, that, well, isn't the EB1A only for, scientists? And I say, no, it's not. It's definitely not for only scientists. Of course, for scientists, it's a little bit easier to provide objective evidence, but you don't need to be a scientist to be able to apply for the EB1 or be even eligible for that, along with the EB2 and a W. So get that out of your thoughts. The other one is, of course, the classic, you have to have a PhD. Well, I think that's related to the publications misconception, but you definitely don't need a PhD. There's no degree requirement in the regulations, as opposed to maybe the EB2 and a W does have a little bit of a degree requirement, but that can also be overcome in the EB2 and a W sector. But those are kind of the two main misconceptions that I hear. And of course, the premium processing factor, that by paying for the premium processing, you're able to bypass everything and get that green card in 15 business days. That's not true.
Recent updates to EB1A or any interesting trends that you observed in the recent past?
Yes, there's been updates and then trends. So USCI has published a policy update on some of the criteria and how to interpret some of the criteria. So that policy update clarified the membership criteria, for example, that past memberships can be considered in evaluating whether that satisfies the requirements. So it doesn't have to be current membership. So if you were a member of an association that requires outstanding achievement, but you were a member in the past but no longer are, then that can be also included in the evidence. And then it removed some of the language that the press or published material about applicant must demonstrate the value of the work. That's been clarified a little bit. So those kind of clarifications from USCIS were published a few months back. But in terms of trends, and I think we talked about this a couple of days ago, Michael, was this a little bit of an unfortunate trend that I've seen from January of this year, which makes things a little bit more difficult, is a trend that USCIS, if they're not going to approve, they will not issue a request for further evidence, which is their common practice, that they will request some further clarifications or documents that you have to provide them to show that you're eligible. But the trend has been recently that they will bypass the RFE stage and go straight to a notice of intent to deny. So they will go straight into that phase of the process, which I feel that could be challenged in court, definitely, for being against the regulations, at least the spirit of the regulations. And it also, in practice, it will give us less time to respond, because the response time is only 30 days or 33 basically, to respond to the notice of intent to deny. So that is a little bit concerning trend. Maybe this is anecdotal again, anecdotal evidence and information that there has been a batch of new officers at USCIS which did not get the best possible training in terms of adjudicating the EB1A. So maybe that's relating to that, but I definitely feel that this trend is a negative one, and I think that should not be the case. And by the way, those notice of intents to deny are always on the final merits, so they're never about the criteria. They're always about that subjective analysis.
Very interesting, and it's going to be interesting to closely monitor.
Right.
With the onset of the new administration, to see how that changes in it, if it does. So it'll be interesting to monitor that. Now, you talked about this a few minutes ago, but specifically, how can working with a competent attorney increase an EB1A petitioner's chances of success? Where does that attorney come in to really make that difference for them?
There are so many moving parts with the EB1A. So it's not a factory process. It's not a packaging a product and then shipping it out like Amazon. It's more like Every case is very unique. That I've been saying this a lot, but that's just the case here in the EB1A sphere. So the attorney's value comes into play, of course. First of all, assessing your eligibility, because if you're not eligible, that will, of course, save you a lot of time and money. And if you're eligible, then you can start working on the strategy of filing the EB1A. The strategy is very important. We have to take into consideration how we are going to present your case. What are the strengths? What are the weaknesses? Is there something that undermines your credibility overall? So let's say some of the criteria that we are thinking about arguing actually will make your case weaker overall. So maybe we can leave that out. Those kind of considerations are very hard if you're not dealing with the EB1As on a daily basis. I think there are so much at stake with the EB1A. So once you've risen to the very top of your field and you're looking to get that green card, your permanent residency, why do it yourself? Because there's so much at play ultimately in terms of your immigration future in the US. So I wouldn't leave that for chance in my if it was my case.
So Hannu, as we wrap up this video, I wanted to ask you, are there any final thoughts that you'd like to share with the audience about EB1A, about the green card process in general? So the floor is yours.
Thanks. So, I mean, ultimately, like I mentioned many times throughout this video, the EB1A is a very restrictive category compared to some of the others, but I wouldn't let that, deter you from considering the EB1A, because talking with an attorney, if ultimately it doesn't lead to filing the EB1A, will give you tools to start maybe building your profile. Maybe you have more information of what is actually needed, what kind of actions are needed for you in the future for you to be able to file it. And so don't let the, scary talk deter you from considering the EB1A. But I would also advise my clients and my listeners that I would watch out for any attorneys or anyone else giving any sort of guarantees when it comes to EB1A, because that we cannot guarantee any outcome, even though you can put cases on a spectrum. So you can say this case is stronger, this case is a very strong case, this is a little bit weaker, but we can then improve, etc. But there's still, like I mentioned, a subjective part. There's uncertainty whether, even though we do our best, that it will be, we can't say that it will be approved. So if there's somebody out there that says, hey, get your EB1A approved 100% or something like that, I mean, that I would be aware of that, at least, because like I said, it's never a guarantee, especially when dealing with USCIS.
Well, there you have it. Hannu, thank you very much for joining us today. I'm sure that our audience will walk away feeling like they gained a tremendous amount of value.
Thanks.
So thank you for that, Hannu. To our audience, thank you so much for tuning in. Don't forget to like this video and subscribe to our YouTube channel to be in the loop with all the videos that we're posting. We regularly post videos on immigration tips, immigration updates, and other valuable content on U.S. immigration law.